28-12, House Bill number 2514, House Draft 3 relating to public safety.
Correct.
Please proceed in opposition.
This bill has some admirable qualities. It raises the total number of paroling authority board members from 3 to 5. It increases the percentage collected from inmates for victim restitution from 10% to 25% of an inmate's account. It requires, as part of a prisoner's parole plan, a prisoner to leave a phone contact where the prisoner can be reached. Other parts of the bill, however, are cause for concern. During a Public Safety and Military Affairs Committee hearing, Honolulu's prosecuting attorney, Keith Kaneshiro, noted that there seemed to be, and I quote him, a single-minded effort to release more individuals from custody without clearly defining how this will be done, consistent with the needs of both public safety and victim safety, end quote. Some amendments have been made to the bill. However, he still expressed many of his same concerns at a recent House Finance Committee hearing. The first concern is that the bill mandates a pretrial risk assessment within 3 days of an accused person's admission to a community correctional center, unless the accused is subject to county or state detainers, holds or is detained without bail, detained for probation violation, facing revocation of bail or supervised release, or has had a pretrial risk assessment completed prior to admission to the community correctional center. Mr. Kaneshiro stated that the consequences were unclear if the Department of Public Safety failed to meet this 3-day deadline. The bill has since been amended, but the uncertainty remains. Further, while the current House Draft 3 has been amended to call the assessment an internal assessment, it requires the submission of the risk assessment to the court hearing the inmate's case. I'd like to note the testimony of Mr. Lindblad, bail agent and former pretrial release officer. He strongly objected to the idea of a risk assessment within 3 working days. That is too little time for an accurate assessment. He noted that sometimes accused persons are still under the influence and may not provide proper information for an accurate assessment. Further, it may take time to obtain background information. The second concern is with regard to the fact that if a parolee violates parole, the longest amount of incarceration that he or she can receive for the violation is 6 months. The exceptions are for those who have 1, have been charged with a felony, 2, left the state without permission, and 3, violated conditions applicable to sex offenders, or 4, have been previously imprisoned for violating the conditions of parole on the current offense. As Mr. Kaneshiro has noted, if there are factors that lead the paroling authority to believe a particular offender should be incarcerated for longer than 6 months, up to his or her maximum term, then HPA should have the discretion to make that decision, as this is clearly within its area of expertise. The third concern is that the bill mandates supervised parole release of Class A, Class B, and Class C felons prior to the expiration of their maximum terms. The length of supervised release varies by felony class. Given the way the bill is drafted, the board may set an earlier release date if it wants to, but if it doesn't set an earlier release date, then the paroling authority cannot deny supervised release to a maxed out inmate, regardless of whether or not the inmate is a management problem, regardless of whether or not the inmate refuses to cooperate with those in authority and refuses to acknowledge that he is responsible for his or her own actions. We should consider that such individuals may be among those who recommit crimes while on supervised release, or who may abscond while on supervised release. Maui County Prosecutor John Kim, in a recent Civil Beat article on January 18th, stated, "I don't see why we should extend supervision. They are just going to run away, and that has been our experience. My concern is that this bill will pass due in part...
Representative Pine, would you yield your time? Representative Rivera, okay, please proceed, Representative Marumoto.
Thank you, Representative. My concern is that this bill will pass due in part to the perception that we need to increase efficiencies and reduce the prison population. A common statistical soundbite is cited in support of the bill is that while crime rates are down, the state prison and jail populations are up. Perhaps we need to ask ourselves, could it be that the crime rates are down precisely because the people who commit the crimes are in prison? The bill makes unspecified appropriations for a number of employees, including parole officers. Before one votes for this bill, we should heed what Mr. Kaneshiro has noted. What you need to have is the parole and probation officers in place before you take the inmates out. I would add that it's going to take a while to find the right people to fill those positions. Hardworking, dedicated employees will be needed to deal with potentially troublesome offenders. In the same Civil Beat article, Bert Matsuoka, chair of the Hawaii Paroling Authority, stated, "Some parolees are refusing to cooperate and have a real attitude problem. For this reason, I have noted I will be voting no on House Bill 2514, House Draft 3. Thank you.
Thank you very much.